be seated.
Right off the bat, we're diving into a legal chess match. The judge just benched the jury so she can drop some serious hearsay education on Mr. Brooks. Buckle up, because this is where legal procedure meets courtroom drama.
Mr. Brooks, before I have you question this witness any further, it sounds like to me that you are attempting to offer through this witness the statements made by Mr. Lascano. If that is what you are trying to do, you may not do that. You will have to call Mr. Lascano as a witness if you so choose, if he's on your witness list. But that your questions are seeking to elicit hearsay from this witness. That's why I had the jury removed, so I could explain my ruling and why I'm going to direct you not to ask this witness questions about what Mr. Lascano may or may not have said.
I'm reading directly from his report.
That would be double hearsay then, because it's not you need Mr. Lascano here to say what he told this officer. If you are attempting to offer it for the truth of the matter asserted, which is what I believe you are doing, you're attempting to establish the veracity of something Mr. Lascano either said or didn't say through another witness.
Now here's a teachable moment. Hearsay isn't just legal jargon. It's a rule that keeps unreliable gossip out of court. And what Brooks is trying to do? Classic example. The judge is making it crystal clear. If you want the story, bring in the storyteller.
That is hearsay.
So it's not hearsay for the prosecutor to bring up.
I'm not going to talk about other rulings. There's been an objection by the state, and I'm sustaining the objection, and I'm directing you not to ask this witness questions that would call for this witness to say what Mr. Lascano said. That is hearsay. That is textbook hearsay, Mr. Brooks.
I don't think it's fair for me to object to hearsay from the prosecution along the lines of the same type of thing.
I'm not going to have a debate on what may have come in previously. I know you've made a number of hearsay objections, many of which the answers that were being provided were not hearsay. But I would direct your attention to 908.01 of the Wisconsin statutes. You have that book in front of you that I provided to you a number of days ago at the beginning of this trial, or near the beginning of this trial. There's the definitional section of the statutes, which defines hearsay. And then if you go on to 908.
Oh, boom. Statute time. 908.01 to 908.03. Wisconsin's hearsay laws in full effect. And the judge? She even handed Brooks the rule book days ago. So, there's no excuse. This is like trying to play Monopoly without knowing what go to jail means.
I know what hearsay is.
0.02. That's obviously one you may want to look at as well. And then 908.03 has the exception. So unless you can give me an exception, sir, as to why this witness should be allowed to answer those questions, I'm going to, again, direct you not to ask
directly
these
from
questions.
his report, the report that he wrote. Nothing is coming from. I'm reading directly from his report. That's what I have.
Doesn't change the fact that it's hearsay.
You said what?
That doesn't change the fact that it's hearsay.
So
it
his report
creates
is
another
hearsay?
level of hearsay. It's an out-of-court statement.
So
not this witness made, but what another witness made. So you have to.
So I can't read from his report that he wrote.
You can't ask this witness questions that call for a hearsay answer unless there's no objection from the state. Or you can convince me there's an exception to the hearsay rule that applies. Do you have an exception you'd like to offer to the court?
So I might as well not read the report that he wrote then if I can't question him about the report that he wrote.
Okay, now it's getting spicy. Brooks still doesn't get that reading from a report doesn't make it magically admissible. It's like photocopying a rumor and expecting it to become fact. The judge isn't having...
That's your misunderstanding, sir, what is hearsay. And all I can tell you is I'm sustaining the objection. I'm going to bring the jury back out, and we'll go from there. All right, Madam Clerk, bring the jury out, please.
Clear bias. Clear bias.
Mr. Brooks, I understand
I
you
don't-
may
I don't
disagree
consent to
with
or agree to
the...
being called that name.
Wait for it. Brooks insists he's not even the defendant, calling himself a third-party intervener. That's a whole other rabbit hole. Is it legal theory or legal theater? You decide.
For the record, again, I'm here as a third-party intervener on behalf of my client. I don't know why that's not understood by now. So I guess I can't bring up the plaintiff either, huh? Tacit agreement.
All right.
Thank you, everyone. Please be seated. Continue with your questions, sir.
Well, I gotta tread lightly.
The jury will disregard that last comment.